Nobody there. All right, we're down in session. Gentleman Sasser presiding.
All right, good morning. Nice to see everyone this morning. We have case management conferences hearings. All right, I'm going to go ahead and call them out then. Oh, which case you heard? I'm sorry.
Oh, I didn't mean to, like...
Oh, I'm sorry. Ms. Grossman?
I had an agreed order.
Oh, yeah, I'll take the agreed orders, absolutely.
No, okay.
If you have any agreed orders, you can please hand them up to the bailiff. Thank you so much.
It was a cancel sale,
Yeah, I'm going to go ahead and cancel it. You want another sale date?
45 days.
45 days. Okay, got it.
So you'll let us know the date?
I sure will. Michelle, again.
Proposed case management.
Well, hold on. Oh, that's good.
Because we're agreed.
Okay, come on up. Which case management are you here?
It's,
Cowboy versus Schittenberg,
What's the case number?
17CA000162.
Hold on, 17. I got it. 26. Number 26, yes. What's the status?
Judge, we have a motion for summary judgment that we need to have set.
Okay, let's set that for hearing within the next 30 days, please.
Okay,
Okay?
thank you.
You can do that at UMC.
thank you.
Thank you, guys. All right. Reverse Mortgage Solutions versus Unknown Heirs, motion for default. Reverse Mortgage Solutions, Unknown Heirs, come on up. Good morning. All right, this is your motion for default. Good morning. And I read your motion. Anything to add?
Nothing, Your Honor.
Okay, I'm going to go ahead and grant it. Have a great day.
Thank you, Judge.
Thank you so much. U.S. Bank Trust versus Rouse, please. U.S. Bank Trust, Rouse. That's right. Good morning.
Matthew Sisio, on behalf of the plaintiff.
That's your motion for summary judgment.
Yes, this plaintiff's motion for summary judgment.
I read it. Everything looked in order. Anything to add?
No, yes,
Okay,
Your Honor.
I'm going to go ahead and grant it then.
Okay. I did not pass in the final judgment. May
I
I?
need that, yeah. I need the final judgment, please. And when would you like your sale date?
As soon as possible.
All right, so Michelle, 35 days sale date on this. Thank you so much.
Thank you.
Thank you, have a great day. 35 days sale date. All right. Wilmington Savings versus Barrington, please. Motion to reset sale. Wilmington Savings, Barrington, anyone here on that one?
Right there, Judge.
Is that yours? Okay. All right. And do you want another sale date?
Yes, Your Honor.
When first available? Okay, 35 days. Got it. Okay, 35 days sale date. Towns versus, is it Ferry, please? Motion to strike. Do you have a team on Towns versus Ferry? All right, come on up, guys. We have a quarter. Okay, that's fine. We'll just wait for council.
You called Towns versus Fair?
I did.
Yes. So we on behalf of the defendant.
Okay, is plaintiff's counsel here?
Could I see?
Oh, then we have to wait. Okay, I'm here. Okay.
Thanks.
Thank you so much. Glenwood Village versus Lake Pine Estates, please. All right. Good morning. Nice to see both of you guys.
Good morning, Your
Good
Honor.
morning.
Alan Ross on behalf of Glenwood Village.
Yeah.
Ruben for Lake County.
Good morning. This is defendant's motion for mediation, and I read your motion. Would you like to add anything to the motion?
Other than, I think we should mediate it sooner rather than later. These are two associations adjoining property owners. This is a case that I think should be resolved before the attorney's fees dwarf what's at stake.
Got it. Any objection?
Yes, Judge, the concern is we've had substantial negotiations, both pre-suit and after suit, which have been unsuccessful. A lot of negotiations back and forth. Our position is we think we need to do some additional discovery, perhaps file some additional motions before the case is ready to be mediated. So,
What other discovery would you need to do, and why would you need to do motions in advance of mediation?
well, it's just, my concern is that unless we get some issues teed up and so that they understand what the issues are, and we get a clear understanding as to what's going on here. For example, there's an issue as to whether this is a license and whether the license should be canceled, which really hasn't been teed up at this point.
Well, you can always do multiple mediations. So let me grant your motion for mediation. If it's unsuccessful, then you can tee up the issues in the motions thereon and do a secondary mediation later on. So motion's granted.
I have submitted a blank order.
Okay, that's fine. I'm going to go ahead and grant it then.
All right, thank you very much.
You guys have a good day. Freiberg versus, Ehrenberg versus Whitworth Farms, please. Objections to interrogatories. Ehrenberg, Whitworth Farms, do we have a team ready? Good morning, is the other side here?
No, not yet.
Okay, then let's wait then.
Okay.
Okay, I'm going to go ahead and call case management conferences now at this time, guys, okay? First up, I have Freiberg versus DeSisto about resetting the trial date.
Yes, Your Honor, and I'm here, but counsel for the defendant told me he's before Judge Curley, he'll be coming back.
Okay, no problem.
Thank you.
All right, PNC Bank versus Ortiz.
Ortiz.
Ms. Grossman, she'll help you later on then, okay? Thank you so much. Michelle's got to listen. She'll help you in a bit, okay? All right, thank you so much. Anybody here on PNC Bank versus Ortiz? 2018 15767. No? Smith versus Kress? 2018 15644. No? Bernier versus Sapala? 2017 3806. No? All right, I'm striking out. San Michelle Andros Isles versus Turwick.
Good morning.
Good morning. All right, good morning, counsel.
Good morning, Your Honor. I'm Kenneth Trent, counsel for the defendant.
Okay, is plaintiff's counsel here?
Not to my knowledge.
Okay, all right, case dismissed.
All right, will you drop an order? Or should I?
Actually, if you want to fill it up right now, I'll sign it.
I'd love to.
Thank you. Okay. Cornerstone Realty versus FL Communications.
Good morning, Your Honor.
Good morning.
Paul Fitzgerald on behalf of the plaintiff.
Yes.
I don't believe anyone's here on behalf of the defendant.
Oh, okay.
Also Fitzgerald.
Yeah, what's this, counsel withdrew, so what would you like to do with this case now?
Actually, we have a deposition scheduled. I don't know the exact date. David Bixby doing this on behalf of the company.
Oh, okay.
He's been traveling and we'll schedule it sometime during the first or second week in May.
Perfect. Okay, so do you want to do another status conference, maybe 90 days then?
Sure.
Okay, 90-day status conference, Sean. Thank you so much. All right, let me go ahead and do Pasternak versus Zala. Pasternak, Zala, counsel ready on that one? All right, good morning, guys. All right, what is the status of this case?
We're in the middle of discovery. I know that the defendants have been out of the country, so we've been trying to coordinate the depositions of the defendant, and from there we can maybe set it for mediation and...
Perfect. So let me do a 90-day status conference, would that be great? Okay, thank you guys, have a great day, everyone.
Thank you.
All right, Wilcox versus OC Food and Beverage.
Good morning, Judge.
Good morning.
Luke Leroux for the defendants, and I believe this Comiac is appearing telephonically.
Yes, the phone number.
I wrote it on the order, the notice.
Wilcox versus... That's fine. Once you okay, we don't have it. I'll recall the case then. Hold on.
No problem.
Okay. Let me do Holtzman versus von Schmitten. Holtzman versus von Schmitten. Counsel ready? All right. Good morning.
Judge Richard Doyle.
Yes.
I represent Mr. Holtzman in the other von Schmittu case that is pending before the court.
Okay.
Not this one.
Who's got the lowercase number?
I couldn't tell you, Judge.
Okay.
The one you've asked for a case management today
Yeah.
is an eviction
Okay.
action and an action for damages.
Okay.
I'm Mr. Holtzman's attorney in that case is Danielle Michaels,
Okay.
who was supposed to be here, and then the defense attorney, Stephen Meyer, is supposed to attend by phone.
Okay.
If the court could please put this to the back and
Oh, sure.
and
That's fine.
revisit this.
And then we'll look up the other case number for you too.
Okay, thank you, Judge.
Oh, the other case is already going to trial.
Yeah.
Yeah, the other case is already going to trial. So what's going on in this one?
Well, I'm not representing Mr.
Okay.
Holtzman in this one. That's Ms.
The other case is
Michaels.
already going to trial. So I'll call you back then, okay?
Yeah,
I'll
I
call you.
understand we're the backup. for
Yeah,
this
but
week.
you're likely going to go to trial. The other one's likely going to go to trial next week. So they're likely going to be reached to go to trial
Oh,
next week.
I was told the case in front of us is going to go forward.
Probably get resolved. So be ready to go to trial.
Yes.
Okay? All right, thank you so much.
Thank you.
Gonzalez versus First Protective. Counsel ready?
Judge, I'm on that one.
All right, good morning.
Good morning, and Anthony Shaw for the defendant, First
Yes.
Protective Insurance Company. The Office for Opposing Counsel spoke with your judicial assistant, and
Yes.
he's going to appear telephonically.
Sure, yeah, your phone number.
I got that. It's, can I just?
Yeah, what's the number?
786
786
271
271.
7637.
Okay, let me give him a call. good morning. I'm calling you on Gonzalez versus First Protective. What's the status of the case?
Spoke to council yesterday. The appraisal process has gone through and payment was issued. It's just a discussion with regards to our attorney's fees.
Okay.
That's pretty much it. I'm gathering the hours that we spend in order to send over a request and discuss with both council. It shouldn't take much.
Wonderful. So you guys are going to have a hearing on the attorney's fees?
Yeah, I think so. I think if you want to set up another
Status conference in 90 days, you think that would be good?
maybe we can do that, yeah.
Perfect. 90 days status conference. All right, thank you guys. Go ahead and follow your attorney's fees motion then.
Judge, who's on the phone?
Counsel on the telephone, they need the court reporter needs your name.
Sure. Edgar, E-D-G-A-R, Kelly, K-E-L-L-Y.
Okay, thank you so much, counsel.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Thank you. JH Portfolio versus Farley. JH Portfolio versus Farley, 2018-6971. No? Okay. M.A. Dinkin Law Firm versus Heretic, 2018-1856. No? Kaufman versus Culture City Plaza, 2013 case. Nobody's here. All right, we're dismissing a lot of cases today. TDAH Inc. versus Paramount Point, 2018-7709. Okay. Gailey Acquisition versus Magic Jack.
Good morning, Your Honor.
Good morning.
Jared Levy for the plaintiff.
Yes. And what's the status of this case?
Well, before I say anything, the lawyer for the defendant asked that I give you his phone number.
Sure, I'll call him. Yeah, what's the number?
786
786
322
322
7395.
Okay, let me give him a call.
His name is David Axel.
Okay, I'll call him.
It's good to see you.
David Axelman.
Oh, Mr. Axelman, good morning. This is Judge Sasser. I'm calling you on Galley Acquisition versus Magic Jack, and counsel's here. Good morning. Counsel's here in the courtroom. What's the status of the case?
Well, I've been wondering the same thing. We filed a motion to dismiss, I think, back in September. That's been pending. I don't believe any response has been filed.
Oh, well, we probably need to set that for hearing since the motion's been pending since December, right?
Judge, the other thing I would say on that is what I'm going to do, I'm going to file a motion for leave to amend.
Oh, okay.
So I think
that'll make that move then.
Yeah, I would think we should be able to get that done within the next 30 days.
Okay, that's fair. So they're going to simply file a motion for leave to amend. The motion to dismiss will be moot. So I'm going to require that the motion for leave to amend be filed within 30 days.
Perfect.
Did you say within 30 days?
30 days, yeah.
Okay.
Okay, perfect. And then we'll do a 90-day status conference after that. Okay, perfect. Thank you guys. Have a great day, everyone.
Judge,
Yes, that's order. Thank you so much.
Thank you.
All right, let me go ahead and do Spine Ventures versus MD Spinal Care. Counselor ready? All right, good morning. Yes. And Mr. Rubenstein, we got your email. Mr. Khan, good to see you. Good morning this morning. And Michelle, did the order go out on the motion for rehearing on this one?
That's actually the other case.
Oh, it's the other,
Serious
oh,
Defense
the
Defense Senate
okay,
case.
okay.
Well, yes, we did receive it.
Okay, good. Okay, just wanted to make sure. All right, and we have a court reporter? All right, good morning. Could I get appearances on the record from all counsel?
Craig Rubenstein on behalf of the plaintiff.
Ben Cohen on behalf of the defendant.
All right, good morning. And what's the status of this case?
So the status of this case, Your Honor, this is a action judicial dissolution. It was an agreed order previously to issue subpoenas to 5 non-parties. There have been some documents produced, but the production has not been complete. I sent an email to Mr. Cohen asking for additional information. Mr. Cohen actually drafted an agreed order of dissolution, which I did a red line on. May I hand that up so everyone can see where we are on that?
Great. Thank you so much.
So the attachment to the email has, the original order is drafted by Mr. Cohen with my red line of it. And really the only substantive distinction between the two is found in paragraph 2D, which I added.
I see that, yeah.
Which addresses the pending subpoenas that I've just referenced.
Okay.
Beyond that, I changed the 30 days to 90 days. But other than that, there are no substantive revisions to it. Yet nonetheless, Mr. Cohen has objected to the entry of that order. His primary position being apparently that the complaint does not allow for any claims to be filed It's just for a judicial solution, but of course, part of the winding up is to marshal assets and prosecute any claims the partnership might have.
Okay.
And that's what this discovery is really directed towards. So I'm a little perplexed as to why Mr. Cohen's objecting to the entry of an order that's consistent with what he drafted in terms of the wind-up process and the potential of claims being brought, a receiver being appointed, etc. But we're not there yet, and depending on what the discovery bears out, it may be moot. I don't know yet.
All right, response, please.
Well, my position is, ever since I took over the case, our position is we don't object to the dissolution of the corporation. The issue is what happens after that, and it's all directed by statute. It's not directed by the lawyers. It's all directed by statute, which tells you exactly what you need to do, as I'm sure you're aware of that.
Yes.
So my position is that the dissolution should occur, and then if there are things that he thinks are necessary, he needs to ask you to appoint somebody to do it. He doesn't get to do it.
Oh, so you don't think it should be, so you agree it has to be pursuant to like a motion then, as opposed to by court?
And I think it needs to be done by motion. I acknowledge that I drew the initial a few days ago. And then when I asked and had conversation with Mr. Rubenstein about what does he think is supposed to happen next, he said, oh, well, I'm going to take my discovery. And I said, well, that's not what the statute says.
Well, can we just do it that way then? So can we take this language out?
That's exactly what's written here.
Okay.
What's written here is, if you look at paragraph 3, it says, either party may seek relief as described above by requesting such action by the court. So the court's reserving jurisdiction to hear these issues, but I still have to come before you and file a motion to get any of that relief.
He's saying nothing's going to happen absent a motion and a specific separate court order.
That's what my whole issue was, is that who is going to do it? If he's going to say, oh, Judge, I want to come before you because I want to do...
No, he has to do, I agree with you, he has to do separate motions on every single one.
Sure. As long as they're separate motions, and then Your Honor has to appoint somebody.
Yes.
It's not separate motions.
No.
It's got to be an independent person.
No, you're exactly right. It has to be, I think you guys are all on the same page with respect to the statute. So what I'll do is I'll go ahead and grant this agreed order as drafted, but I agree, and we have a court order for the record. There has to be separate motions, independent for each individual one, and then you'll have a right to object to every single thing as well. And then we'll do it that way then.
Sure, and I have a clean version of this if that's something that works.
All right, thank you so much. All right, nice seeing you both. And I'll set those for hearing whenever you guys are appropriate.
Okay, thank you.
Thank you guys. Have a great day, everyone.
You don't need the other blank order, right?
I don't.
Okay, thank you, Judge.
Shore versus Edison Insurance, please. Anyone here on Shore versus Edison Insurance? No? Pellegrino versus Bindell? Pellegrino, Bindell? No? All right, first call 24/7 versus Tower Hill Select. No? PNC Bank versus Puglisi? Counselor Ray? All right, come on up on PNC Puglisi. All right, good morning. Nice to see you guys.
Good to see you, Judge.
All right, and where are we on this case, guys?
Good morning, Judge. Alan Tomlinson for PNC, the plaintiff. There's a motion to dismiss that's been set for hearing before the court May 28th.
Good, okay.
It's got an interesting legal issue, but it's going to be set May 28th.
Excellent.
There's been some fairly intensive settlement discussions, and I'm optimistic that it might get resolved.
Wow, that's a good sign then. Okay, well, that sounds wonderful then. So we'll see you guys on the 28th if you guys don't settle it then.
Thank you, ma'am.
You guys have a great day.
Thank you, Judge.
Okay, let me do Carnes versus Anna Polsky, please. Carnes versus Anna Polsky. Good morning. All right, good morning, guys. And here comes counsel. And what is the status of this case?
The case is not an issue, but the parties reached a written settlement agreement.
Oh, excellent.
The real estate transaction that is at the heart of that hasn't closed yet, but I don't know why.
Oh, can we do maybe a formal mediation? Would that be helpful, or?
Well, we're still trying to close it. The issue is with the lender. I spoke to the lender yesterday, and they're claiming that it's going to be closing soon. However, this has been kind of going on for quite some time.
Yeah, that's why we set up a case management. What can we do to help you guys? If anything,
if we can set it for, I guess, another case management conference.
Okay. Do you know when the closing is going to be?
They told me within 10 days because there's a rate that's locked in. I guess what happened was when they went to reassess the loan, the reserves were not the same that they were in 2018. So that's
okay. So that's fine. So hopefully it closes within 10 days, and then we'll get it done, and then the case can get settled. Then we hope.
Or we can file a motion to enforce the settlement.
Exactly at that point in time. So what I'll do on this one is I'll just do a 60-day status conference rather than a 90-day, and hopefully that'll keep the pressure on to get the case settled. Then.
Can we show that 30 days?
30 days is even better. 30-day status conference.
There's a motion for extension of time outstanding. Do you want to do an agreed order on that? Your motion for extension of time to respond to the complaint?
Yeah, let's put that in the order. That'll at least move the case forward procedurally, but 30 days to ask conference to definitely keep the pressure on you guys. All right, thank you guys. Have a great day, everyone. All right, Tech Marine Construction versus Daytona Blue Tide and counsels by telephone. Defense counsel? Okay, let me give them a call. Oh, I'm trying to reach attorney Kevin Robinson, please.
Okay, and may I actually, hold on one second, hold on.
Okay, thank you.
Sorry, I thought they were still on a meeting. May I tell who's calling?
Sure, this is the court calling on Tech Marine Construction versus Daytona Blue Tide for the hearing.
Okay, thank you.
Thank you. Oh, Mr. Robinson, good morning. This is Judge Sasser. I'm calling on Tech Marine Construction versus Daytona Blue Tide. What's the status of the case?
Yes, Your Honor. In October 10th, 2018, Your Honor entered an order allowing plaintiff's counsel to withdraw. Your Honor gave the plaintiff 20 days to retain new counsel to enter an appearance. Nothing has happened since Your Honor entered that order, so new counsel hasn't appeared. Plaintiff hasn't done anything to prosecute the case.
Okay, case is going to be dismissed. They're a corporation. They have to be represented by counsel. They failed to hear a case management conference, so we'll send you an order today dismissing the case.
Thank you, Your Honor.
Thank you. Have a great day.
Bye.
Okay. U.S. Bank Hudson? Anyone from U.S. Bank Hudson? All right, good morning, counsel. All right, and what's the status of this case?
So, Your Honor, the defendants are actually in a trial mod.
Oh, okay.
So we would request to roll over to CMC.
That's fine, we'll do that. We'll do a 60-day CMC.
Sounds good, Judge.
Okay, perfect. Thank you so much.
Did you want me to write up an order?
Yeah, just put that in the case management order.
Thank you, Judge.
Manganon versus American Integrity Insurance.
Good morning, Your
Good
Honor.
morning.
This case was actually has settled.
Oh,
we filed a notice of settlement.
Congratulations.
So we're just waiting to have the documents executed and we're to be dismissing.
Thank you so much.
Okay, thank you.
Thank you so much. Gonzalez versus Yermina. That's really that one?
Good morning.
Good morning. All right, good morning, guys. And what's the status of this case?
You had previously filed a default at the end of last year, and then we had a notice of appearance from counsel, and I believe, unfortunately, she got in a car accident.
Oh, okay. That's fine.
We were set for trial,
Well,
and
no, actually, we were waiting to receive proof of service. They were claiming my clients were served, and my client said she wasn't. So we wanted to know if we could get the.
Can you send a copy of return of service? Just send a copy of the return of service. Are you guys?
I mean, it was filed.
Oh, it was filed.
But we couldn't get access to it, so
From the
she's
court file,
we
you
were
couldn't
not
get
able to
access?
get
Oh,
access.
just email our copy, then that's fine then. And then, so at that point in time, have you answered the complaint yet?
No, I'm going to answer once I get.
Perfect. So when
we get the.
Return of service today, let's do that, and let's say answer within 20 days, is that okay?
And can we get the default vacated?
Yeah, default's vacated. Default's vacated, answer within 20 days, let's send copies over to the return of service then. And then we'll do a status conference in 90 days then.
Perfect.
All right, thank you guys, have a great day. All right, Galvan versus Bates. All right, good morning, counsel. And what is the status of this case?
We had settlement negotiations. I felt we were apparently not. There's story parties are ex-boyfriend and girlfriend, so it's difficult. I think an order to mediate would be appropriate.
Okay, I'll do an order mediation, and then we'll do a 90-day status conference. Just fill out the blank order then.
Okay.
90 days management order. Thank you so much. Alley Financial versus Aiken. Counsel ready? All right, good morning.
Kenneth Mayor for the defendant.
Yes. And what's the status of this case?
Last time I was here, the defendant was not here.
It's the second time, so the case is dismissed. Have a great day. Jacques versus Citizens Property. All All right, good morning, counsel.
Good morning, Your Honor.
All right, good morning. And what's the status of this case?
Well, before we begin, Judge, the plaintiff's counsel provided me with a number.
Yeah, let me give him a call. What's the phone number?
Actually, I should say, I believe it's now plaintiff's former counsel.
Oh, okay. All right, and you are, sir, are you here on that case? Jocks versus Citizens?
Yeah, where's John?
Okay, that's fine. Come on up, guys.
And sorry, Joe Mendelson on behalf.
Yeah, that's fine. Come on up. I know we've had you guys here before then. All right, so let me give them, do you guys, it's your former attorney. Do you want me to call your former attorney? You guys represent yourself.
We represent ourselves.
They represent themselves.
He wanted to.
Oh, okay, he's welcome to listen in. All right, what's the phone number?
305.
305?
735.
735?
3966.
Okay,
It's
let me-
Attorney Stephen Silver.
Okay, let me give him a call.
Good morning, thank you for calling Silverbird Freedom. How can I help you?
Hi, good morning. This is just Sasser. I'm calling on Jacques versus Citizens.
Yes, ma'am, give me just a moment.
All right, thank you so much.
No problem.
Hello, this is Peter.
Oh, good morning, counsel. This is Judge Sasser. I'm calling on Jacques versus Citizens. Your former clients are here in the courtroom, and this is a status conference. And what's going on at this time? I know you guys are representing yourself, so what would you like to do with the case?
We still were waiting on our two checks for the two cases.
Yeah, so where are
For
we
the
on the
second
checks?
one,
Yeah, 'cause I know you guys were here before.
The second one, they have a company that doesn't exist anymore.
Okay.
We Googled them, we called the Better Business Bureau, we had one proof that they don't even exist.
Okay.
So we can't cash the check without that company that's on there. We didn't even know who they are.
Okay.
And they added them.
All right, let me hear from the defense counsel.
Sure, Your Honor. We settled the case at mediation. We have the checks to disperse. An issue apparently arose between plaintiff and their
Former counsel.
There's some issue with, I guess, a charging lien. We're not certain who to disperse the checks to at this point. Looking for court guidance before we...
Counsel on the telephone, who should the money go to?
So, the mediated settlement agreement, it says in there where the money goes.
Okay, so I don't have a copy of that. Where does the document say the money goes?
I believe, without having that in front of me, Your Honor, I believe that there was half of the money was to go to the attorney and the other half was to...
Let me take a look. Let me see the document. Let me see what it says where the money's supposed
See,
to go.
with that, we didn't even know that it was 60,000. They had my mom and dad sign, they didn't understand what they signed.
Yeah, it says, oh.
And now they want, this is 60,000, it was 30,000
All right,
for
here's
each
what we're gonna
case.
do.
And they want to hold.
Okay, here's what we're gonna do. We're gonna give half the money directly to the plaintiffs. The other half will go to in the,
They're two separate cases.
no, half them, and the other money will go to the court registry, and we'll have a separate hearing on the retaining lien. Okay, because that way you'll have to prove your retaining lien. I'm sorry?
To the court's attention.
What? I'm sorry? Yes, go ahead, counsel.
If I
Yes.
may. On January 8, 2019, you issued an order that says the mediated settlement agreement is hereby enforced.
Yes.
Shall be split pursuant to mediated settlement agreement's terms, and the plaintiff shall endorse all checks necessary today.
Yes. I know, but at this point in time, he's saying that there's a retaining issue with that, with respect to that. And I'm fine to do that, but before I disperse anything, I just want to make sure it's a valid retaining lien.
On the retaining lien.
I know. So what we'll do is half the money will go to the plaintiff's counsel, the other half will go in the court registry, and then we'll have a hearing to resolve the amount of the retaining lien.
You said plaintiff's counsel.
I mean, plaintiff's former counsel.
So we're going to get our fees. And then,
No, your fees are going in the court registry.
okay, so the plaintiffs are going to get their money now.
Yeah, plaintiffs are going to get their money. You guys are going to get your half now.
Yeah.
The other half's going to go to the court registry, and then plaintiffs, your former attorney is going to set a hearing on the on his amount of the fees, making sure it's okay.
Your Honor, I just want to make clear that we will disperse the half of the money to the plaintiffs upon receipt of executed settlement
Yes.
documents. Make sure we
You
get
need to get all the documents the defense counsel needs, okay? That way you'll get your money, but you have to sign everything that they need.
What is it
Okay?
that they need?
These settlement agreements, releases,
To what?
saying you won't sue them anymore.
Oh, after?
Yeah, after you get paid, okay? So you gotta sign, they won't give you the money until you execute releases.
Okay, but they have that imperial justice on the check. On our check that they don't exist, so we don't even know who they are.
Okay, it's gonna be payable directly to you then, okay?
Okay.
Payable directly to you, but you need to sign releases.
Because they just sent some new checks out again.
Are they in a group, are they disputing the amount that's supposed to be payable to us?
Are you disputing that the attorney gets half?
It's two separate cases. We're
Okay.
just not figuring it out.
Yeah, they may not dispute it. They may not dispute it. Right now, we just need to do one thing at a time.
Yeah.
So there may be no dispute, and the plaintiffs may agree to it.
Well, that's what I'm saying, if they agree to it now, then we can end all this.
I don't know if he agrees to it now. Do you agree to it now?
For the second case, no.
You think for this case, yes. For the second case, no.
What appears to have happened is we resolved two separate claims
Yeah.
at mediation together.
Yeah.
We didn't know that.
Yeah, that's
That's where the
yeah.
confusion
That's
is.
what-
That's where the confusion is, because two cases got resolved, and then one person thought only one case was getting resolved, so then there might be an issue.
Well, I think then, no, respectfully, Your Honor, then if the court is gonna intervene into the mediated agreement, then it's possible that that $30,000 that you're dispersing to them today could be null and void because we don't have a settlement.
Was the $30,000 for one case or two cases?
It was $30,000 for one case and $30,000 for the other.
Okay, then this is a mess then. Then you're
Yeah,
gonna have
that's
to have.
not what the settlement
That's not what the settlement agreement says, counsel. I mean, that's not what the settlement agreement says. Do you guys want the $30,000 for both cases or not? Otherwise it's not gonna happen on one case. Otherwise, nothing's gonna happen. You're not gonna get any money. You can either get the $30,000 for both cases, or you can get zero and it'll just be more litigation. It's up to you.
We'll take the $30,000 for what we're supposed to get to that.
You'll get the $30,000 right away for both cases if you agree to that.
For both one?
Yes.
What about another one?
Both cases, ma'am. Otherwise, you get nothing, and you're gonna have to have more litigation.
What happened? What?
You have to have more hearings, more lawsuits, more litigation.
I mean, for the first $30,000, we get that anyways. For the second one, can we develop more litigation and whatever it is?
You can't do it that way.
It's two cases.
You can't do it that way.
But, Judge, these people trick us. They say they make...
Then you have to have hearings, I have to have testimony, ma'am. The question is, ma'am, I have a courtroom full of people. You can either go ahead and take the $30,000 on both cases or not, otherwise you have to have more hearings.
Go ahead.
What do you want to do?
Take the $30,000.
30,000 on both cases?
Yes.
Okay, they're willing to take the 30,000 on both cases, so that at least helps citizens out at least. So they'll take the 30,000 on both cases, the other 30 will go in the court registry, and then we'll have a hearing on the amount of the retaining lien.
Is in my name.
But that's been agreed to.
Yes. So talk to them, call them and say, send me an agreed order.
Yeah, I was going to say, Your Honor, as far as an order, I'm not sure exactly.
What we need to do then on the order is we need to indicate it that $30,000 shall be for settlement to payment to plaintiffs directly for settlement of both cases. Do that pursuant to an agreed order, they will sign. And then the other $30,000, do you agree to the attorney getting the other 30, or do you want to have a hearing on that?
A hearing.
They want to have a hearing on that, counsel.
Okay, but then I can't agree to them having their first $30,000.
I already ordered it.
But then, Your Honor.
That's part of the settlement, that's part of the mediated settlement agreement.
And the mediated settlement agreement says that we would be.
I understand, counsel, but you'll have a separate hearing on your retaining lien. Okay? Plaintiffs get $30,000 today, because that document says that they get $30,000. You guys get your $30,000 on both cases, so at least that moves the case forward.
Yes, Your Honor, and if we're reissuing, because I have checks with me, but like they're saying they're issued to another party as well, so I'm gonna have to get checks reissued. I can't give it to them.
Yeah, no, don't give them today then. 20 days to get the checks from. All right.
Days.
Okay? So they'll get the checks corrected then. Okay? All right, thank you guys. Have a great day. Mark, can you give this back to me? All right, thank you. So this was on both, so this was also on Stevens versus Citizens. This was on both cases, right? Stevens and John, no, so let me do the other one. Stevens, come on up on Stevens versus Citizens. Okay. Oh, the other one? Okay.
That's fine.
All right, good morning, guys. This is Stevens versus Citizen. And what is the status of this case?
Yes, Your Honor, Tony Bismarni on behalf of the plaintiff. This case was just recently served. We had filed a complaint. We named citizens incorrectly, so we had to amend the complaint and amend the summons.
Not a problem.
So it was really just
Okay,
served.
not a problem. So let me do another 90-day status conference.
Okay,
All right,
that's
thank you,
fine.
guys. No problem.
Thank you, Your Honor.
Okay, let me
Thank you.
recall St. Andrews Isle versus Cherwick. Council showed up on this one, plaintiff's counsel. St. Andrews versus Cherwick. All right, Michelle, just to file it, they can set it at a later date and time. All right, let me go ahead and do U.S.
Your Honor, I'm sorry, did you call sorry, was
Yes,
it
Cherwick. Yeah, I just did, yes. Are you plaintiff's counsel?
Yes, Your Honor, I apologize for the delay.
Not a
in
problem.
getting here.
All right, what's the status of the case?
A motion for summary judgment has been filed. The affidavits will be filed by the end of this week.
Perfect.
And we will then set up a hearing date accordingly.
Okay, no problem then. So I'll just indicate that the summary judgment shall be set for hearing within 30 days. Perfect, we'll put that in the order.
All right, thank you so much.
Thank you so much. No problem, have a great day. Let me do PNC National Bank versus Ortiz. Council's here on that one? All right.
Yes, I am.
All right, good morning. And what is the status of that case?
A bankruptcy was filed,
Oh, okay.
so I don't know if you want
Do you know, is it a Chapter 7? What's the status?
I believe it's a Chapter 7.
Okay, no problem. So we'll do another 90-day status conference then.
Okay.
Thank you so much. Thank you. All right, more foreclosures. U.S. Bank National Association versus Jackson. Motion to continue trial. Council ready?
Yes, Your Honor.
All right, go ahead.
Actually, it's a Michael Olson for the plaintiff, Your Honor.
Yes.
There's a trial mod that just started April 1st.
Great, okay. So, but no objection, right?
Yeah, and the trial set for April 19th, so asking the trial be continued or...
I'm going to continue it, that's fine. Trial be continued then, and we will go ahead and do a 90-day status conference.
Thank you, Your Honor.
Thank you, guys.
In that order, I'll fill it
Yeah,
out.
just fill out the order. All right, AIX Mortgage versus Alfred, plaintiff's motion for summary judgment. AIX Mortgage, Alfred? Okay. Let me recall the case managements that I needed to recall then. Actually, Freiberg versus DeSisto. Both sides here, come on up. Here. Come on up, guys. All right.
Morning.
Good morning, guys. All right. And counsel, we had to reschedule the trial for you. I'm so sorry about your family. When can we set this trial for you guys?
April 29th is what we were hoping for.
April 29th? And how many days? Is it 4 days still?
4 days,
Okay.
maybe bleed into Friday.
Let me just make sure.
You're on
Tuesday, I have a special slide. Put your back up behind it, if that works. Yeah.
Plaintiff's counsel been very nice.
Yeah.
After that had stroke. He just passed away.
Oh, I'm so sorry.
So,
I didn't know
I really just got my hands full, and I
okay.
understand how they feel, but
Okay.
is there,
Do you want, well, you're going to be back up the 29th. I already have a special set that week anyway.
Here's our dilemma, Your Honor, and believe me, we're respectful
I know,
to counsel, and we've done everything to help.
You just had a death in the family.
Understood.
So.
It's become more complicated, though, because last Friday, they filed a proposal for settlement in the case. And under the rules, as we understand them, they have 45 days within trial, otherwise it's going to be used as a sword against us.
Okay.
So hopefully, we can balance the...
Can we set it in May sometime? Is that okay?
I was, would May 27th work?
That's Memorial Day.
And that's beyond the 45 days. I mean, I would be okay being the backup on that day.
And there's a good chance I'll get reached.
And we're still talking about, a few weeks away.
Okay,
And
that's fine. Let me just put you in the backup on the 20th. Like I said, I'll put you on the backup. It would be that Tuesday we'd start. Yeah. So the
The
backup
only
that
problem
April.
is my co-counsel is out of town on the 2nd and the 3rd.
Well, that doesn't have any...
Yeah, that's before the 2nd and the 3rd. We'd be finished, right?
Well, the 29th
It's
is,
4 days. We start Tuesday to Friday would be the trial, right?
Right.
right, but the 29th of April goes into May 2nd and 3rd.
Okay. You want to do the week after? The first week of May?
Week after is fine.
Is that? I have a special set, but you'd have to be back, because like I said, I'm special set on these other cases. You'd have to be back up on the special set behind it. Okay? You'd be the #1 backup to the special set. The first week of May is up. I mean, we need to get this case tried, counsel, and I continued it because of the family situation.
Okay, so we've got an expert who's available that Friday, on May the 1st, I think it would be. Would that be?
We could start, but he said his co-counsel.
Oh, that doesn't work. It's the following week that would.
He said his co-counsel. Counsel, I can't, why does your co-counsel need to be here that week? Who's your co-counsel?
His name is Mitch Catler. His daughter is graduating, I believe.
Okay, we're just gonna try it that week. There's only so many things I can do. We're gonna leave it on the 27th then, okay? Yeah, whatever that, so.
The 29th?
Number one backup the 29th.
Number one backup the 29th.
Number one backup the 29th. I'm so sorry. There's only so much I can do. I've tried to accommodate everybody's schedule. And the plan's been very accommodating and, you know, I can't accommodate graduations also. There's only so much I can do. Okay, so number one backup. There's a good chance you're gonna be reached, okay?
And can we get the name of the other case?
Yeah, Michelle, give you everything. And I'm so sorry, but you guys, there's a good chance we're gonna get you guys, okay?
All right,
I promise. All right, thank you guys so much. All right, let me go ahead and do, Wilcox versus OC Food and Beverage. We're ready on that one? All right, good morning.
Yes.
Okay.
We have the number.
Yep,
For
what's the phone
Plaintiff's
number?
Counsel.
Yeah.
Would you like me to give it to you? It's 305
305?
467
Uh-huh.
8361.
Let me give them a call.
Hello, good morning, Eva Cruz speaking.
Oh, good morning, Council. This is Jim Sasser. I'm calling you on Wilcox versus OC Food and Beverage. What is the status of the case?
Hi, good morning, Your Honor. I spoke to opposing counsel. We are ready to proceed to trial in September.
It's okay. Is that okay? September 12th?
September's fine. I can get it order.
Perfect. Perfect. How many days for the trial? Send your trial order.
We would need probably we have 16 plaintiffs, so we'll probably need about 7 days of trial.
Do you agree? 7 days?
I agree.
Okay, we'll send you a trial order for 7 days in September today.
Very good.
Thank you, guys. Have a great day.
Thank you, Judge.
Thank you.
You too, bye-bye.
Okay, let me do 7 days. That's Wilcox versus OC Food and Beverage, number 8. All right, thank you. You're excused. Have a great day. All right, let me do Holzman versus von Schmitten, and we have the other case number now too. We figured that out. Okay, all right.
I have the phone number for
Yeah, what's the number?
Stephen Myers, 561 289
289
8415.
Okay, let me give him a call. Counsel, good morning. This is Judge Sasser. I'm calling you on Holzman versus von Schmitten. What's the status of the case?
Good morning, Your Honor. Thank you for calling. Is Mr. Doyle there?
No, counsel's here in the court.
Here.
No, she's here.
Danielle.
Okay.
Yes.
This is an eviction case. It was originally filed by Mr. Holtzman in county court. It was transferred to circuit court. It was then transferred to your division. We had a motion to consolidate it with a prior pending action, which is a negligence case.
And that negligence case is back up for trial next week.
Correct. And so we had a hearing some time ago. Mr. Doyle's office opposed the motion to consolidate that I had filed. I think, quite frankly, they really should be consolidated. Ms. Holtzman, von Schmitter was a tenant. She was injured on the property and has a negligence case against the landlord, Mr. Holtzman, and his wife. And then Mr. Holtzman evicted her because she couldn't work. She lost her job because she was injured. She couldn't pay the rent. She got evicted. And so that's why I think they're connected, and there's just largely overlap.
Okay, all right.
And she claimed that the expenses from the eviction as part of the damages of the negligence.
Okay, all right. Let me hear from counsel then.
I want to apologize. I was under the impression that these were consolidated. The prior counsel.
So you have no objection to the consolidation?
I do. I wanted to oppose it. I couldn't make the hearing. Richard Doyle's office, his former counsel.
It's not consolidated.
Okay, so
the negligence is going to trial next week. There's a good chance you're going to be reached.
When it got transferred,
the new case number. They didn't put me on the docket, so I didn't get notice of anything. So I didn't know what was going on in this case.
Okay.
I'm ready to file the motion for final judgment on my affidavits to bring this.
Okay,
before
that's
you.
fine. So why don't we do this then? The negligence trial will remain back up for next week then. There's a good chance you're going to get reached. I think the case ahead of you is going to settle. So there's a good chance you're going to get reached then. And then the council in this case is going to move forward on the eviction action then.
Okay, Your Honor, may I ask, I know there was a hearing in that Towns case, which is the case ahead of us.
Yeah.
They had a motion.
They're here. They're actually here right now. I'm going to talk to them in a few minutes then.
Pardon me?
We'll let you know what the status is of that case, okay?
Okay, thank you.
All right, thank you guys. Have a great day. Just follow your motions.
There was never an order entered for the motion to consolidate.
Denied, just put that in your order. Okay. Thank you. All right, let me go ahead and call Towns versus Ferry, since you guys are number one next week. Come on up. Quarter. Okay. All right, you guys are number one, and let's see where you guys are. And let's go ahead and get appearances on the record from all counsel, please.
Thomas Sutter, on behalf of the plaintiff, Mr. Towns.
Toby Pro on behalf of the defendant.
All right, let me just confirm, how many days is the trial going to be?
It should be 3 or 4. I would say 4 to be safe, but maybe 3.
Judge Shepard's very fast, 3 days.
She is.
She's trying to, 3 days.
Well, I don't want to be wrong, so.
Okay, it'll be, I assume 3 days is going to be sufficient. So it'll be a 3-day trial then. All right, so let's do a couple motions. One, we have plaintiff's motion to strike defense expert witnesses and plaintiff's motion to compel better response to supplemental discovery.
Yes, Your Honor. Let's, I'm not going to go forward on the second motion, which is the motion to compel discovery responses.
Sure, yeah.
So we're just going to address the motion to strike. Your Honor, if you can allow me to just give you a brief chronology.
Sure, absolutely.
Background. So this was on a trial docket back in March. There was some disclosures late in the game from experts. So we, by agreement, moved the docket until obviously this docket. In the order that your judge signed, said, look, part of the plaintiff is entitled to get these depositions of the experts, provide 3 depositions dated by February 8th. We got the radiologist done. They provided one for Dr. Simon. That was the first date that was provided was January 31st. To be candid with you, we did provide that date. We confirmed that date. I don't know what happened with my assistant and there was some confusion, but a couple weeks later, Ms. Pearl was unavailable, so we said, look, can we have another date? They gave us March 21st, and within a day of giving us that date, the doctor's office actually emailed us and said we're not available.
Okay.
Cut to, we said, look, we need another date. They did give us April 11th, which is obviously next Thursday, which was the last.
After the last day of the trial.
Right, and then so that's when I reached out to Ms. Pearl, says, is there anything?
Yeah, how are we going to fix this? We can't do that on Thursday.
No, and I couldn't get Dr. Simon. Dr. Simon was absent. And we did do a chronology for you as well.
Yeah, no, I haven't. No, but what do we do now? We kind of have a problem.
There was no way for me to do it because I was out of town, and we did offer those dates, but
we need a date before Thursday.
I don't think that I can get a date.
I can't try that case then. That's a problem. Otherwise, I have to go ahead and strike the witness. They have to be able to depose him. It's only fair to plaintiff's counsel.
Yeah, I know, and we did offer the dates, and it was never set.
Motion to strike is granted. I don't have a choice.
If I can get a date, if I can get him to do something before trial.
It has to be before trial. It has to be before the I would say it has to be before tomorrow. Yeah. Tomorrow's Friday. So it has to be, how about made available for that by 5 o'clock tomorrow, otherwise you're stricken.
I'm not available tomorrow.
Oh, okay, 5 o'clock today? I mean, this is next week. It's not fair, counsel.
Already at 2 o'clock.
Counsel, it's not fair. It's your choice. If you're going to trial next week, you guys knew that. The witness has to be made available. It's not fair to plaintiff's counsel.
Are you available today if I can get him today?
I have deposition this afternoon.
So fine, but we have to.
At 5, after 5.
Yeah, do it after 5. So it must be made available today, otherwise the witness plaintiff's motion is granted.
I just think it's extremely prejudicial to our defense because
Counsel,
people see minutes.
you didn't comply with the trial order.
We gave him dates and they just didn't set the hearing. They didn't set the depo. We provided the date and they didn't set it.
That's not what counsel said, so.
Yeah, the first time we provided for January 31st, we left it open.
The witness has to be made available today, okay? It's the witness's schedule. If you want this witness, they need to be made available today. I'm happy to go ahead and have the witness testify, but they have to be made available for deposition before trial. Or you guys can do it tomorrow, but counsel's not available. It has to be made available today, okay? So please make the witness available for trial, for deposition today.
All right, thank you.
All right, thank you guys. Okay, all right. And jury instructions verdict form, make sure everything's sent over to counsel then.
Yes.
Okay. Carnes versus Anapolsky, I think we already did that one. Okay. let me go ahead and do foreclosure case, Loan Depot versus Ramirez.
Yes, Your Honor.
We finished all the case management?
Yeah, all the case management.
have a few more that showed
Okay,
up.
then you guys showed up late for case management. Loan Depot versus Ramirez. All right, motion for foreclosure?
Yes, Your Honor, it's a motion for order to show
Yeah,
cause.
I'm going to go ahead and do that then, and we'll set that up for you then.
Okay, and you'll serve in mail. Perfect, thank you, Your Honor.
All right, if anybody's here for case management, I called them all. Come on up one at a time. You guys are late. What case you guys here on?
Good morning, Judge.
Good morning.
Daniel Jensen on behalf of Smith versus Gary Crease. I stepped out for
Oh,
a
this week,
second.
not a problem. What's the status of Smith versus Crest? That's number 3, Michelle.
We're trying to serve the defendant. We just recently, as of 2 days ago, got his address and trying to effectuate service.
Not a problem then. So we'll do a 90-day status conference.
Thank you, Judge.
Thank you so much. That's number 3, Michelle. All right, what case you got?
It's Bernier v. Sepola. I'm counsel for Mr. Sepola. I was here since the quarter.
That's good. Bernier never showed up, so the case is dismissed.
No, Mr. Roy is in Judge Gillens, and
He's not here. Okay. We'll wait till he comes back then.
Okay.
I'll call him again. I'll call Bernier versus Sepola. That's fine. All right, let me go ahead and do Ehrenberg versus Whitworth Farms. All right, counsel ready? Both sides good? Good morning. Yeah, this is defendant's objections to plaintiff's interrogatories. Both sides ready? All right, let's go ahead. Good morning, reporter. No? Okay, good morning, everyone. This is defendant's objections to plaintiff's interrogatories. I always need to ask counsel, have you had a chance to meet and confer?
We have.
Okay, wonderful. Which interrogatories remain?
Basically, all of them.
This is a standard slip and fall case where a woman allegedly fell on a curb right in front of a public. So plaintiff has propounded initial interrogatories. There's about 77 subparts, which exceeds the
77
30.
subparts of interrogatories. I don't think we'll be doing that now. So 77 subparts of interrogatories? I've never heard of 77 subparts of interrogatories.
It's not like there's A, B,
In a
C.
slip and fall case?
It's more like, what is your name, what is your address? They're counting those as subparts when they're talking about subparts.
Okay, you guys need a special set of 77 interrogatories?
It's also just standard interrogatories approved by the Supreme Court. They have the personal injury negligence, and I feel like the slip and fall falls under that, which the
Why not
Supreme Court
look at the
requires.
standard interrogatories?
Because many of the standard interrogatories, Your Honor, are directed at an individual. We're not suing an individual, we're suing a company. They asked for
But there's
things.
a reason the Supreme Court came up with standard interrogatories is to make your lives easier, make my lives easier. Why deal with 77 separate interrogatories when we have standard Supreme Court interrogatories?
There's not
Okay,
77.
all right, these will be happy to be special set.
There's 22 in the actual standard form. If he wants to ask more questions, he can add to the 22 to get to 30.
Otherwise, you're gonna have to go online and set them for hearing.
Okay.
All right, go ahead and go online and set them for hearing. Thank you, guys.
Thank you, Your Honor.
All right, thank you, guys. Brody versus Lift, please.
Morning, Your Honor.
Speed trial. All right, good morning. All right, good morning, guys. This is Brody versus Lift, and this is plaintiff's motion for speedy trial, and I read your motion.
Oh, you did? Okay, I'm sorry.
I read it.
There's a proposed order there too, Judge.
No problem, that's fine. No problem. All right, let me just ask you, I am obviously aware of the statute. Is there any objection?
Yes, Your Honor.
Okay, what's the basis?
Your Honor, this isn't your run-of-the-mill car accident case. You're dealing with Lyft here, so you're dealing with the Transportation Network Company. So you're dealing with the Transportation Network Company statute, which is a relatively new statute. The issues are going to have to be fully briefed
That's fine, we can do it. I'm really good. You guys are really efficient, and so am I, so we'll get it done.
Your Honor, on top of that, dispositive motions are going to be filed, argued, special set. Your Honor, there's 3 parties on the accident report. Those parties are obviously going to have to be deposed. They may lead to other parties. In addition, Your Honor, the Florida Supreme Court Rule Judicial Administration 2.25 indicates that 18 months is the standard.
But that's not, but we have a statute. I have to follow the statute.
Your Honor, in addition to that, the statute indicates that the burden is on the movement to demonstrate that there are some sort of health concerns. The plaintiff has not indicated any sort of imminent health concerns or exigent circumstances that will prevent him from getting 18 months through to the trial period.
Let me just ask
There's
you,
no
what are
supporting.
you looking for to go to trial?
As soon as possible, Judge. He's 85 years old.
He's 85.
He's got all kinds of health issues. Counsel and I talked about it yesterday. We sent everything to them,
Okay.
not only in response to the production request, but I did a pre-suit demand. I sent everything.
Okay.
So they've got everything to
Okay.
see what he's got as far as.
So let me set you guys out for trial maybe 6-7 months out down the road. You can always file a motion for continuance.
7 months works, Your Honor.
Okay, is that okay?
I'd like to get it sooner, Judge.
So how about this? How about we set it to actually October? Is that okay?
Sure.
October it is?
I think 7 months is more suitable based off of the complexities that I just mentioned. Your Honor, there's no medical documentation supporting the fact that he's not going to make it through the next.
August is, October is 7 months.
Thanks, Judge.
Okay, have a great day.
I've got it over there for you, Judge. It's blank.
Yeah, we special set everything, and we don't roll cases in this division, so you get reached.
Excellent.
Thank you, guys. Have a great day.
Thanks, Judge.
Thank you, Your Honor.
Thank you all. All right, let me go ahead and do Poppet versus HC Realty, please. Motion to compel defendant's corporate rep to answer deposition questions. All right, good morning,
Your Honor.
All right, come on, guys, come on out.
Good morning, Judge.
Good morning. We have court reporter, and if I could get appearances on the record from all counsel.
Yes, Rick Ruby on behalf of the plaintiffs.
Elizabeth Campbell on behalf of defendant HCF Realty.
All right, good morning, everyone. This is plaintiff's motion to compel defendant's corporate rep to answer deposition questions and for sanctions. And Mr. Ruby, I read your motion. You may proceed when you're ready.
Nothing to add, Your Honor.
Okay, response, please.
Yes, Your Honor, we object on a number of bases. First and foremost, there is nothing additional to compel from our corporate witness. She was prepared for the deposition
So
itself.
why didn't she answer the questions?
She did answer the questions, Judge. She referred Mr. Benton to documents. A corporate witness can only gain knowledge either from employees, from the company records, or...
This was a 30B6?
It was.
Then she has to have knowledge.
And Judge, the knowledge that she had, she testified to. She said the records, and I have records here if Your Honor would like to see them.
You have to, under the rule is succinct and straightforward. There's a reason we have it. Mr. Ruby is exactly right. You have to have a witness prepared with knowledge. I'm going to grant the motion. She has to answer it, and I'm going to grant his fees and costs for the deposition.
Your Honor, we would object to the fees and costs because under the rules, there's been no court order yet. Sanctions are inappropriate unless there's an order where there's non-compliance.
No, not in this situation where she didn't comply with requirements. So she's got to just, I'm sure they're not excessive. I'm sure they're not unreasonable.
We'll work it out, Judge.
You guys can work that out because, I mean, otherwise he has to go back and retake the deposition again.
We're not asking him to retake the deposition.
But he needs to retake the deposition. That's the problem. So you, under 30B6, you have to have the burden of making a witness prepared to answer those questions. The witness can't say, I don't know, under 30B6 deposition.
I understand, Judge, but the questions that he's asking, our witness doesn't have knowledge of.
Then you need to have a witness with knowledge. That's what the rule provides.
But Judge, we don't have the knowledge. It's a different entity that has the knowledge. That's the issue. He wants to know about repairs. The only knowledge that my client has are the records, and we've testified that there are records. The day-to-day management of the property was handled by a different entity.
Witness prepared. The motion's granted and the sanctions are granted. Thank you guys. Have a great day. Thank you all so much.
Your Honor, may I approach real quick?
Sure, of course.
Judge, we have another motion.
Sure, yeah, let's do the other motion, yeah.
It's our motion to continue trial, Judge.
Okay, sure.
We're on the trial calendar, or I guess the trial notice for the end of April.
Yeah.
For that trial notice. We just got plaintiff's list of experts for the very first time in March.
Okay.
And they hadn't been previously identified, even though there's discovery out there asking for these experts to be identified. We have attempted to set depositions, but we've got 10 experts. There are 3 mold experts, a damages expert, and 5 doctors.
Got it.
We're running into trouble trying to get dates before this trial
Can we
period.
give dates before the trial?
Judge, this case was pending since January of 2016.
Okay.
The only defendant who has now been dismissed from the lawsuit, Cushman and Wakefield, was the only defendant that did discovery during those entire 3 years. Counsel did not ask for a deposition of the plaintiff until 6 weeks ago. She didn't ask for a deposition of any of the experts until 2 weeks ago.
Okay.
If you look at the docket, they did 0 discovery.
But they're entitled to do discovery, so I just need to have, as long as you can make it available, that's not a problem.
Judge, we've complied with every request, every single request.
Okay, that's fine then. So they're going to make all the witnesses available for deposition for you.
So are we going to special set this?
Every trial is special set in my division.
Okay.
So, and I'll set you at the end of the docket, that's not a problem. And Mr. Ruby's counsel's going to make sure that every single witness is available for deposition before trial. So the motion for continuance is denied. You guys will remain on the docket. You'll be at the end of the docket, but you're going to get a chance to take every single deposition you would like to do.
Okay.
Just when you say the end of the docket,
It's 6 weeks, whatever that is. It'll probably be May sometime, end of May, June.
Judge, there's still a motion for summary judgment.
Oh, go ahead and file it then. You have filed it for hearing?
He's filed, it's not set till hearing till the end of May. And so it's hard for us to...
We'll do it before, that's fine.
Judge, it's just on their affirmative defense.
That's fine.
It's not burdensome.
Okay, that's fine. We'll be able to get it done before the case is tried then. All right, thank you guys. Have a great day then.
Thanks, Judge.
All right, let me go ahead and do Veluso versus Colony at Delaware. Yeah, I'm sorry.
Oh, no, sure. I was approaching on the UMC. Your Honor permitted me to have the annuitant on the telephone.
Sure, yeah, I did, yeah.
That's
Which case, yeah.
Thank you very much, Your Honor. And her name is Nicole Tercey.
Yeah, I just need a phone number.
So I've got a city one.
Yeah,
That's what I was going to do.
Yeah.
Okay, Nicole? Okay, prepare, I'm going to put you on speakerphone with the judge.
Okay. Just, can she go ahead and get sworn in then? Is she going to testify?
She is, Your Honor.
Okay, all right, raise your-
Well, I'm not sure if you need,
I don't need, doesn't need to be sworn. Go ahead and ask her questions then.
okay, and Nicole, are you under the influence of any drugs or alcohol at this time? Okay, and you understand that you're going to be receiving $15,103 and therefore foregoing the annuity stream that you would get in the future?
I do. Okay, all right, that's, I'm going to go ahead and grant it then.
Okay, thank you
All
very
right,
much.
send the order then.
We will, Your Honor.
All right,
Thank you very
guys.
much.
Have a great day.
Okay, have a great
All right,
day.
let me do Lucy versus Colony at Delray Beach Homeowners Association. Council Ray? All right, folks are ready. Come on up on this one. All right, is the other side here?
Not that I know, Your Honor.
Okay, all right, you represent the plaintiff or defendant?
Defendant.
Okay, all right, this is defendant's motion to determine reasonable fees, and I read your motion. Would you like to add anything to the motion?
Just that Dr. Navarro is a plastic surgeon. He's a treating physician, and given a 40-hour work week, he would be making over $4 million.
That's a lot of money, I agree. So that's, what do you think is a reasonable fee then?
I would defer to Your Honor. I would ask for $500.
Yeah, I think 500 is reasonable for an expert of this quality. Let's do 500 then.
Okay, thank you.
All right, thank you so much. All right, do we have both here? Yeah, just put that in your Bernier.
Yes.
Come on up. All right, good morning, guys. All right, Mr. Roy, we have you now. And what is the status of this case, guys?
Judge, I looked up the docket. There's a pleading I need to file.
Oh,
It was
okay.
not filed.
Okay, so we can do that then. What do you need to file?
An amended complaint. It's long overdue, and so I apologize about that. I
Not a
thought it
problem.
had been
Just a
done.
gentle reminder. How much time do you need to file the amended
10
complaint? Is that okay?
That's fine.
Okay, so 10 days to file the amended complaint. Just put that in the case management order.
Thank you.
Perfect. Anybody else here for CMC or UMC this morning? Come on up. Anybody else here for case management conference or UMC? Otherwise, I have the 9:30. That's the only other hearing I have. All right, 9:30. That's it. Come on up on the 9:30.
Judge, I'm on that.
Okay.
I can stay up here or...
Wherever you're comfortable, it's fine. Okay. Thanks, Michelle. Okay. All right, good morning. Nice to see everyone this morning. Let me know when you guys are ready. Madam Porter's ready. We'll go ahead and start. Good morning. Nice to see everyone this morning. We are here on, is it Barbara Carpy versus Ocean Dunes Condo Association, and we're here on a motion to dismiss. Could council please state their appearances for the record?
Morning, Your Honor. My name is Ronald Dana. I represent Barbara Carp, and Ms. Carp is available.
Make yourself comfortable. All right, council.
Warren Fisher, also representing Ms. Carp. I can get
I'm sorry. She couldn't hear you.
Morgan Fishman, FASHMA, representing Barbara Carp.
All right, council.
Carlo Marichal for the defendant, Judge.
Jonathan Miller as well on behalf of the defendant.
Good morning, Your Honor. Carolina Shear on behalf of the defendant.
All right, good morning, everyone. As I indicated, this is the motion dismissed. I went back and read the complaint. I have the entirety of the motion, and you may proceed when you're ready.
Good morning, Judge. This is the fifth amended complaint. I know this court had the last hearing. Again, the plaintiff did not comply with the pre-suit requirements as required under the law. They are alleging failure to grant access to the books, as well as the essentially illegal meetings being held under law that's subject to pre-suit arbitration. Therefore, counts 1 and 3 should be dismissed. And I did mention to Mr. Dana that we were not clear that we are seeking count 3 dismissed as well, because they did incorporate for reference counts 1 and 2.
Okay.
And then if we look at the governing
Let
document,
me do one thing at a time. Why not? I mean, we've been here before. So,
It's quite,
I mean, why not comply with the requirements?
Your Honor, because we are not, when we were here last time, the court had maybe 3 issues. With respect to the arbitration issue,
Yes.
Chapter 718.122 requires certain disputes be subject to non-binding arbitration.
Correct.
We deleted the statutory cause of action.
Okay.
Currently, the complaint alleges
Let me tell you, what's count 1 at this time? What's your take on what?
we have breach of contract,
Okay.
we have negligence. Last time we were here, the court asked me to identify the sources of duty.
Yes.
I think I nailed it, Judge.
Okay. But let me ask you, do these arise from the inspection of books and records?
No.
They don't.
No, there are multiple violations.
Let me have defense counsel read that into the record.
Judge, if you look at paragraph 21, subsection D and 30, the plaintiff alleges the association failed to make available documents for inspection. If you look at paragraph 21, section B, says that the failure to have regular board meetings and when meetings are held, fail to distribute minutes of the meetings to the homeowners. Section 21D, denying access to the records.
I mean, so you don't care about the records?
The judge, the basis, the legal basis for the claim is in the Articles of Incorporation, Article 7.
We have statutes. We have to comply with Florida statutes.
The judge-
If you're seeking records, I have to dismiss it. It's up to you. If you're not seeking the records, it's up to you. You got to do pre-suit. The statute, I have to follow the Florida statutes. I don't have a choice.
Judge, if there's a provision in the bylaw that predated the statute, which it did.
We talked about that last time. Statutes are statutes. I don't make the law. I just enforce it.
Okay, well, Judge, in order to get this going, that's a very small part of the case.
Okay.
So I will delete the issue.
We need to
regarding
dismiss it
records.
then. We need to dismiss that portion and you need to go to pre-suit then on it. If you're not going to seek it out, need an amended complaint.
We're asking for
As to the
dismissal.
records.
Correct.
Yeah.
At the records?
Yeah, but the rest of the complaint.
Okay, all right, so
Another
the
story.
motion to dismiss it is granted. And how much time do you need to amend?
What?
There's-
Motion to dismiss is granted. You have counsel. How much time do you need to amend? Because I need a clean complaint without the
Without those in there?
Yeah,
10 days.
10 days. 10 motion to dismiss is granted, 10
Thank
days.
you,
to amend.
Judge. And with respect to negligence, does the court want to hear arguments as well? So
No, let's wait on it because we're going to have a clean
Okay.
complaint then next time.
Thank you, Judge.
All right, thank you guys. Have a great day. Thank y'all. Excellent work, both sides.
Thank you, Judge.
Thank you guys.
No.